welcome back. Thank you for hanging in there with us as we move further into the afternoon. I'm Liza Goitein, co-director of the Brennan Center's Liberty and National Security Program, and I'll be moderating our discussion on oversight within the executive branch. This panel moves us from external oversight to internal oversight, which is a real, one of these things is not like the other kind of shift. To begin with, the Constitution creates a system of checks and balances among the three branches of government precisely because the framers didn't think the branches would do a very good job of checking themselves. Yet, the federal government has grown so massive, and the information disparities between the executive branch and the other branches has grown so great that it's really not possible or desirable to leave oversight entirely to the Congress and the courts. In the intelligence area in particular, there is substantial reliance on internal oversight. That's in part due to some of the limitations on congressional and judicial review in the national security context, which we heard about on the earlier panels. And in fact, when administration officials talk about some of those limitations on external review, they often invoke the level of oversight that happens from within. So this tells us that this internal regime is at least in part being used to compensate for a lesser degree of external oversight, as well as to complement that oversight where it exists. And the panoply of oversight of overseers within the intelligence community is indeed impressive. The NSA's surveillance operations alone are overseen by no fewer than 12 executive branch offices. So to name just a few of them, the NSA's Director of Compliance, the NSA's General Counsel, the NSA's Inspector General, the NSA's Civil Liberties and Privacy Office, the Inspector General for the Intelligence Community, the ODNI Civil Liberties Office, and the Privacy and Civil Liberties Oversight Board. But of course, the existence of oversight mechanisms doesn't guarantee their effectiveness. Quantity does not ensure quality. In the last couple of years, a series actually of FISA court opinions were released showing that the NSA had routinely failed to comply with court orders in each of three major collection programs. Now, on the one hand, it was internal oversight that caught these problems and led to their correction. On the other hand, these violations were numerous, significant, and widespread, and they continued for years before the government detected and reported them. The effectiveness of oversight can, of course, be impacted by the rules that govern it. So, for example, Congress has authorized the heads of intelligence agencies to block Inspector General investigations involving sensitive national security matters. And these kinds of rules and constraints can, in theory, be changed. There are some more difficult questions, potentially, surrounding the dynamics of internal oversight. And in particular, how an internal overseer that exists within an organization and within the organization's culture can maintain the necessary objectivity. We've certainly seen some courageous and thorough and rigorous investigations, and one example that comes to mind is the reviews of national security letters that were performed by the Justice Department's Inspector General, the former Inspector General Glenn Fine. We've also seen Inspector General reports that outsiders have described as whitewashes. And we recently saw the CIA Inspector General step down after antagonizing CIA leadership with a critical report. And that was the report on the agency's monitoring of Senate Intelligence Committee members who were investigating the torture program. So these observations raise a number of questions that I'm hoping we can touch on today. Can internal oversight, on which we are increasingly reliant, perform the same functions as external oversight? What are some of the advantages as well as the limitations of oversight from within? And perhaps most important, what changes can be implemented to improve internal oversight? I could not be more enthusiastic about the group of people that we have put together to discuss these questions, and I'm going to introduce them very briefly, but there's much more information on them in your programs. First, Michael Horowitz is the Inspector General for the Department of Justice, a position that he has held since 2012. I'm going to skip over some of your background. He's held many positions within the Department of Justice, starting, I believe, as a prosecutor in the Southern District of New York. And he went to Harvard Law School, but I'm still glad he's here. Bula, bula. Margot, sorry, nobody got that except like you. Okay, Margot Schlanger is a professor of law at the University of Michigan, and her research and teaching focus on civil rights and civil liberties and how to induce large and complex organizations to respect them. She also, importantly, served in 2010 and 2011 as the presidentially appointed Officer for Civil Rights and Civil Liberties at the Department of Homeland Security. Next, we have Shireen Sinar, who is an assistant professor of law at Stanford Law School, and her scholarship focuses on the role of institutions in protecting individual rights in the national security context. And she's also worked as a public interest attorney with the Asian Law Caucus and the Lawyers Committee for Civil Rights of San Francisco. And finally, we have Alex Joel, who has been the Civil Liberties Protection Officer for the Office of the Director of National Intelligence since 2005. 10 years. 10 years. Almost said 15. 10 years. In that capacity, he leads the ODNI Civil Liberties and Privacy Office and reports directly to the Director of National Intelligence. So I'm going to start right in with questions for the panelists. And my first question is for Inspector General Horowitz. Michael, what has your experience taught you about the advantages and the challenges of oversight from within? And I'm sure we'd all love to hear actual examples if you're in a position to give them.
I've certainly learned a lot in 3 years now on the job as Inspector General. Spoke at length with Glenn about his experience as IG and some of the issues and challenges he faced. I've now seen it up close and directly myself. We've released a 215 report, a follow-up report on NSL, a follow-up report on some of the other authorities out there. We've issued a 702 report. Unfortunately, so many of those are not public in the full way we would like it to be out there. And we talked about that a little bit as well. But there are a number of challenges, but I think a number of very positive reasons why an IG's office can have an impact. And I think you've seen some of that over the last 10 plus years with what our office has done. We are, of course, within the agency, and one of the things we have to make sure we keep in mind in everything we do is what the IG expects of us, which is to be independent. We may be in the agency, but we're independent of the agency. And so we talk about the department. If you look at our reports, you'll see us referring to the department or the Department of Justice, and then there's us, the OIG. We very much try and keep the two separate. We'll talk about this further about access. Being within the department, we should have complete unrestricted access to all the records we need to do our work. That has been an issue over the last 5 years for our office. I've testified at length about it. It began just before Glenn left. It continued during the acting IG's tenure, and it's continued for the last 3 years as I've been IG. We have ultimately been able to get all the records that we asked for, but it has been a struggle in a number of areas, including some of the national security reviews that we've done. But one of the advantages in the way we are set up is that we should have complete access to all of the records in, for example, the FBI's possession as we're doing these reviews of their national security authorities. Another advantage is we have the staff that we have that has done this work has been with us for many years. They develop an expertise. We understand the department from being within the department, and that continuity is very important. The folks that have worked on the most recent 215 reports worked on prior reports, worked on 702, worked on some of the other reports. We have a continual knowledge base that I think is a significant advantage, and we have an understanding of the organization and the culture of the organization, and have some idea of going in of the struggles we're likely to face, the pushback we're likely to hear on a substantive level and a procedural level. But I think we bring that as well. We also have access to people, which is a very significant part of what we do. We have the right to interview and to compel, if necessary, interviews of all DOJ employees. And we generally have not had difficulty getting people to speak to us voluntarily. We usually haven't had to use the authority to compel. We have had on occasion difficulty getting folks who have left the department, because we don't have the ability for people, staff that have left the Department of Justice to compel them. We don't have, for example, testimonial subpoena authority, although that is in in both IG reform bills that are pending in Congress. So there are limits to what we can get in terms of testimonial information from individuals who've left the department, but for staff that are still within the department, employees that are still within the department, we have a right of access. They have to speak to us. We can compel their testimony if they refuse to speak to us. It is a termination offense within the department.
So before I go on to Margot, I want to ask you a little bit more about the access issue that you mentioned, because I think that's very important, and I'd like to give you some more time to flesh out what that issue has been.
So what occurred back in 2010 is the FBI Office of General Counsel took a completely different legal position that it had taken in the 8 years prior to 2010. In 2002, just to rewind, in 2002, we first got authority over the FBI and the DEA when Attorney General Ashcroft extended our jurisdiction to cover both organizations. In 2003, Congress codified that decision. And during that 8-year period, in the various national security reviews we did and other reviews that we did of the FBI, we got access to documents. There's always a tension, there's always a back and forth about volume, scope, all the things that occur in any process that involves requesting large amounts of documents, but we never had interposed to us a legal objection. It was all based on sensitivity, security issues, how we were going to maintain records, whether we really needed 50,000 records, is there any way we could refine the request, those sorts of things. It was never about, do we have the legal authority to get the records? That changed in 2010. The FBI Office of General Counsel took the position that with regard to a variety of categories of records, what specifically was at issue at the time was grand jury, Title III wiretap information, and Fair Credit Reporting Act information. We were not entitled to get access to under the IG Act, which Section 6A of the IG Act provides that Inspector Generals, I'm just paraphrasing now, should get access to all records that it requests. It's pretty clear. The FBI's position was, because the IG Act postdated the 3 statutes that I referenced, and since the IG Act didn't reference, it was overruling or limiting the authorities in those, the limitations that exist in those other statutes. Those other provisions apply still. The IG Act didn't override it, and therefore we were subject to the same limitations that others were on the grand jury, Title III wiretap, and Fair Credit Reporting Act information. That seemed to Glenn, the interim, the acting IG, and myself, an interesting, novel change in position when, if you all look, you will find that in 2010, nothing happened to the law. The law didn't change, no regulations changed, no policies changed. The legal position of the FBI changed. So even though for 8 years we had gotten grand jury material, we had gotten wiretap information, we had gotten Fair Credit Reporting Act information, all of a sudden the FBI decided that those decisions that had previously been made were wrong. It's our view, remains our view today, that nothing had changed. The law remains as clear today as it did in 2010 or 2002. And in the intervening years when we got all of that information, yet the FBI changed its position. To give you an example of how that affected the work we did, we were in the middle of the NSL review that we released last year. And in 2009, when we began that review, we asked for Fair Credit Reporting information, and we got it. In 2010, as we were doing a field visit, we found out when we arrived in the office that they weren't going to give us the information that we had seen a year earlier because their legal position had changed in the intervening year. That resulted in you will see this in our report if you look in our report, because we've made public all of these issues. That resulted in a nearly year-long delay in our work.
Wow.
While this issue was pending and remains pending to this day.
What I found interesting about this dispute is that there were, I think, 47 inspectors general who signed a letter to Congress, not only supporting your position, but also sort of intimating that maybe this was a more widespread problem. Maybe not that particular legal claim, but that there were issues with access to information that inspectors general more broadly have. Is that a fair characterization of?
It is, and I think what we have seen as a community, most IGs fortunately have not faced the argument that the law prohibits them receiving information. What most IGs, I think, have struggled with, including us and other examples in other areas, is getting timely access to records. Dealing with all the frivolous, baseless arguments that we face sometimes in getting our work done and getting access to records.
So, Margot, Jack Goldsmith, the former head of the Justice Department's Office of Legal Counsel, wrote a book, Power and Constraint. And in this book, he argues that intelligence oversight is actually at an all-time high, particularly within the executive branch, because of the sheer number of lawyers and compliance officers and others who are devoted to internal oversight. Is he right about that? And if so, can we all just relax and go home?
Well, as a matter of basic fact, yes, he is right about that. There's no question that there are more people inside the executive branch now whose job is to check up on their colleagues than there have been before. The IG's offices are bigger and there are more of them. The offices of compliance they exist now and they didn't used to, or where they did used to, they've moved up in the organization chart. In the IC in particular, there's been this little mini trend of these offices of civil liberties and privacy, like the one that Alex heads, like the one that I used to head, so that there have been new people whose job is in part internal check. Most of them are less independent than the IG's offices. The IG's offices have some unique independence, and we'll talk about that. But the answer is yes, there are more people doing that. The thing about these lawyers mostly, and even in the offices where they're not explicitly practicing law, they are mostly lawyers. The thing about all of these lawyers is that, I mean, this is good for law following because lawyers are good at reading laws and understanding what they require. And so if you have an agency that's interested in following the law, that agency is going to have some lawyers, unless the law is really simple, which, you know, it is not. Right. So this is a necessary change, it seems to me. So, and agencies where the lawyers used to be, you know, banished to outbuildings, they're now in the headquarters and so on, and you can read about that in various memoirs and so on. Or there's a passage in the Church Committee reports where, I can't actually remember who this was. Who was this? It was Senator Mondale asking the question, but I don't remember who he was asking. But he said, well, did it ever occur to you that this might be illegal? And the answer was, what? Seriously, that was the answer. What? Well, you know, illegal, like against the law. And the answer was, no, I don't remember us ever discussing that issue. It wasn't, so I don't think you'd have that conversation any longer. And that's the reason. Lawyers, I don't mean to say that lawyers are an unmitigated good. I'd be interested to know how many of us here are lawyers, but we are not an unmitigated good. We can use our lawyerly skills against rule following too, right? So lawyers, there's nobody better at interpreting rules out of existence than a good lawyer. There's nobody better at reinterpreting what look like plain English words to discover that they contain unfathomable ambiguity that we didn't even see when you read them the first time. Lawyers have excellent rule not following skills too. And even when lawyers, and I think of those things as, you know, somewhat bad faith, but even when lawyers operate in good faith, it is a core commitment of the legal profession that you're counseling your client as opposed to your own ideas about what should happen. And that one of the things that you do as a lawyer is you create and then explain the space that is available to your client. And that's good faith. That's before we get to interpreting rules out of existence and finding ambiguity when there is none. So lawyers are professionally predisposed, I think, to talking about floors. They want to give their clients as much space as possible in which to carry out their client's mission, and that's actually their job as lawyers. I'm not talking about bad faith lawyering. I'm not talking about finding ambiguity where there is no ambiguity. I'm talking about finding ambiguity where there is some. Have you read FISA, for example?
Yes.
It's a tough, complicated statute, you know? So, so what I think is true is that all of those lawyers do a lot for creation of a floor of rule following, and I am on the optimistic side of this. I see people in the audience right here who have told me that I'm crazy, but I don't think I'm crazy. I think this is right. I think that all those lawyers create a floor for rule following. I think they depress the floor a little, but I think nonetheless they create a floor, and that's really important. But I don't think we should fool ourselves. They don't do more than that. The lawyers are not about achieving the right balance between liberty and security. That's you know, it turns out that you know, laws sometimes do that and sometimes they don't. And lawyers don't reform laws. Lawyers are about implementing laws. The Fourth Amendment itself is not, the Fourth Amendment itself, when adjudicated, there's a lot of signs and a lot of opinions that talk about, you know, deference. So if what we're interested in is not mere compliance, but the right balance, the right policy, the right operations, I don't think we should expect that from lawyers alone, although I do think we can expect, you know, enforcement of a slightly depressed floor.
But no, is that a role for overseers? Because what you've just described, finding the right balance, to me is a very interesting concept of oversight, which I think a lot of people would look at that word or that concept and think, well, compliance is what you're looking for. You're looking for the floor. With overseers, do overseers also have a role in sort of looking to see whether that right balance is being struck?
So I think that someplace, somehow, there have to be a lot of people whose job it is to figure out what the right policy is. A lot of people. So let's think, again, since this is a church committee day, let's think about the church committee, right? The church committee didn't stop by saying, there's no statute that bans assassination, so I guess it's okay. That actually wasn't the way that that conversation happened, right? The church committee proposed drafting of, implementation of, and enforcement of a set of, maybe I shouldn't have started with assassination, but in some other areas, a set of new rules. And I think that's a crucial part of an oversight function, and I think, and have written, as you know, that has to happen both within the executive branch, between the executive and between the executive and congressional branches. I think that the congressional branch can only be expected to rejigger the rules every once in a while in sort of a spurt of attention. I'm just, maybe this is a sign of the age that we currently live in, and in a different age I would have different ambitions for the Congress. But that's my ambition for the Congress, that every once in a while something will startle it into, you know, passing a statute.
Maybe on Sunday.
Maybe on Sunday.
For example.
And reconfiguring the rules some. And then in between, and maybe in addition, I think it is the job of the executive branch to not only faithfully execute the laws, but to do so in a way that is as effective and civil liberties protective as it can be, consistent with carrying out the laws and carrying out its obligations. And so I think there should be policy shops within the executive branch. And they could be called things like offices of privacy and civil liberties that do some policy work. And you're going to ask me other questions later, I imagine, where I can elaborate on that. But they could be called other things too. They could be called policy offices. They could be called lots of stuff. But somehow inside the executive branch, the downside of lawyers is that sometimes the lawyers say, yeah, that's legal. And that's legal, which I call the can we question, substitutes for that's a good idea, which is the should we question. And can we and should we are not the same question. And this is something that I tell my 15-year-olds often. And I think the executive branch needs to act on that insight and needs to know that just because something is legal under current law, which may well change if, Congress passed laws, that just because something is legal doesn't mean it's good. And they should ask often, is that a good idea? And that is that a good idea entails taking very seriously both the effectiveness of the proposed course of conduct and the downside negative impact of the proposed course of action as far as both intelligence and civil liberties. And so I think that, I don't know if you'd call that oversight exactly, but I do think that there is a really important role that in order to get that kind of activity in Congress, in the executive branch, we need to create an ecosystem where there's a lot of people ginning up a lot of information and a lot of ideas that are kind of cross-fertilizing and communicating, all in secret. No, not all in secret, but mostly in secret, because I think that's inevitable, where they can talk to each other, and sometimes the should we question gets asked in a really rigorous way, inside and outside the executive branch. And so some of these offices that you're calling compliance offices, I might call them policy offices instead and say that's actually their unique role. I think the IGs do some of this. I think the IGs do more do more compliance.
And I like your church committee example, which sort of combined those functions.
Yes,
it was
yes,
oversight and recommendations
so
together.
so that's the ecosystem idea, and what it does is I've kind of written about this idea of intelligence legalism, which is an idea that all of a sudden rule following substitutes for virtue. And, rule following is not bad. I'm in favor of it. It has some downsides, but I'm in favor of it. But it's not the same as virtue.
Right.
Or if you want to sound a little bit less, Greek, maybe it's not the same. The should we question is not the same. I'm sorry, the can we question is not the same as the should we question.
And we're gonna come back to that, I think, in a little bit. Shireen, I wanted to ask you another question about Jack Goldsmith and his book, which I just want to say that I did actually invite him to be on the panel, but he had another commitment. But in his book, he says that the presence of inspectors general and other internal overseers has actually had the net effect of expanding rather than constraining executive power, because Congress and the courts and the public feel more comfortable in trusting the executive with broad authorities when these overseers are there. Do you think that's right? And if so, is more power but more oversight a worthwhile trade-off?
Right. So in a sense, the question is an impossible one to measure, right? This idea of whether on net the effect of internal oversight is to increase or moderate executive power. Clearly, there are two dynamics at play. So one dynamic is that internal oversight can, and I think in notable examples and instances, has led to limits on national security excesses and, in fact, increased and reinforced the stringency of external review. So, we mentioned one example earlier, the National Security Letters review by the Department of Justice IG from 2007 to 2010. And I think that's a very good example of that, where first, the reviews exposed a practice that had been essentially unknown outside the FBI, this practice of using exigent letters to obtain phone records under false premises and outside standard legal processes. And in doing so, it not only led to a curtailment of that particular practice, but also led the FBI to adopt more stringent kind of internal oversight mechanisms, so to make a more robust internal compliance program and so forth, as well as triggering a more extensive public debate around those issues and additional congressional scrutiny. Similarly, internal oversight has led in particular areas to an increased willingness on the part of courts to move forward with civil rights litigation. So, we see a number of examples where in responding to motions to dismiss constitutional challenges, courts have looked extensively to information that's come out of IG reviews to say, look, there's actually quite some evidence that policies have not been implemented in the way that we should, and encouraging them to to go forward with constitutional review. So I think there's that dynamic of auditors having an incredibly important role in both public transparency on these issues and then in promoting this broader dialogue and reinforcing external oversight. And of course, at the same time, we see that the presence of internal oversight is used by both courts and members of Congress to say, well, it's okay to delegate broader discretion to the executive, and that the fact that we have IG oversight, or other forms of internal control is a reason for us to be less concerned. And we've seen that in multiple legislative debates over the years. So you look at, any major piece of legislation over a number of years, the FISA Amendments Act, the Patriot Reauthorization Acts from, previous iterations of that process. In all of these debates, there are plenty of comments from legislators saying, well, look, we're inserting this provision for IG oversight, therefore it makes acceptable this broad delegation of to the executive. So, I think at the end of the day, in response, to the question, there's no set answer. What it means is, in my mind, at least two things. First, that paying attention to what these internal executive institutions are doing and holding them accountable, ensuring that they are, in fact, effective at what they do is incredibly important. So, for every example of a DOJ IG, which sees its role as staunchly independent and frequently looks to issues of civil liberties and civil rights, there are other examples of IGs who see their roles as in less of an independent term. I mean, they often end up coming across more as defenders of their agencies rather than as offices that are taking a very critical view. And there are some IGs who say quite directly that individual rights concerns, human rights concerns, that's not really part of what we do. That's not part of our core mandate. And I heard that directly from some IGs whom I interviewed a few years ago in part of my research. Holding these institutions accountable and making sure that we are not just establishing organizations without seeing that they're actually being able to be effective is crucial. And the second part, just the last thing I'll say is that I think it's important to distinguish between what these offices can and can't do, and I think Margot's comments go to that as well. Some are mostly about doing compliance and looking at the implementation of policies. Others are particularly useful in pushing back against claims of government secrecy. But to my mind, none of these institutions can really compensate for, what Margot might say is the lack of constitutional floor setting. So, to the extent that courts are sitting on their hands or that Congress is not legislating, that floor does go quite a bit down, and maybe we can talk more about this afterwards, but I have some skepticism about the ability of very internal, sort of subservient offices, framed as whether they're civil liberties offices or policy shops, to affect substantial policy change in where they're not able to leverage sort of a public discussion or be in greater communication with the public. So I think there's some real concerns about that and additional concerns about co-optation for offices that are ensconced sort of firmly within a national security establishment structure.
And your point about getting the information out to the public goes back to what Michael was saying about some of the battles he's had to try to get reports declassified and available to the public. Alex, your turn. The intelligence community exists for the purpose of gathering intelligence, often through surveillance or through the exploitation of human sources. This is an undertaking that is inherently invasive of privacy and inherently secretive. Your job is to promote privacy and transparency. It seems the decks are stacked against you. Why should we nonetheless expect you to succeed?
So first of all, thank you for inviting me. I do want to get to that question, but thank you for inviting me. I am a personal fan of the Church Committee report. I have a photograph of Senator Church and Senator Tower on my desk, the one famous one where he's holding up the pistol. And it was a Darkin, yes, exactly. I've read through key volumes several times. I've learned to be careful about saying which ones I think are the key volumes, because there's a lot of people, a lot of authors here who will argue with me about which ones were the key volumes. And we teach it. We have training that focuses on the Church Committee and the lessons that we've learned from the Church Committee. So in many ways, the framework that we've been discussing over the day, at least in my opinion, is an outgrowth of the lessons that we've learned from that whole experience with the church committee. And I think I was mentioning to Locke Johnson that the Director Clapper himself, the Director of National Intelligence, has very strong and vivid personal recollections of that era, very concerned that we not repeat the mistakes that were made, that were uncovered by the church committee. So thank you for this opportunity. It's very important. So why should you think I will be successful? Well, you shouldn't base it simply on me individually, as is very evident by the fact that this is a church committee event. Congress didn't suddenly invent the idea of civil liberties and privacy function in intelligence when they created my position in the Intelligence Reform and Terrorism Prevention Act of 2004. It was very much embedded, as I've just described, in the lessons that we learned. And those lessons are now manifested in a lot of the institutions that you guys have been talking about. So we are a relatively new thing, the civil liberties and privacy function, but obviously we've had a lot of lawyers. And in fact, Church Committee report said we should have more lawyers. I'm sure at the time the offices of general counsel took that and ran with it to say, yes, we need more lawyers. And we have a lot of lawyers throughout the intelligence community. So these things are very well lawyered. We have inspectors general. I guess they have different, you perhaps have spoken more directly to them about, some of them about how they view their roles than maybe I have, but it's always been my assumption that they are an integral part of this framework. You absolutely have to have independent inspectors general with access to the information they need to do their jobs. So that's another piece of the puzzle. We of course have other agencies outside of government. There's the Privacy and Civil Liberties Oversight Board, so we heard a lot from David earlier today. We work very closely with the Privacy and Civil Liberties Oversight Board to make sure they have all the information that they need to do their jobs. We've heard a range of things about Congress and the intelligence committees. Oh, I also meant to mention the Department of Justice is a department full of lawyers and is very focused on making sure that we are doing things the right way in the intelligence community. And we also work closely, of course, with the intelligence committees and the judiciary committees when it called for by the various reporting requirements. In my view, that level of oversight has been granular. I know that there's a range of opinions about how effective the oversight is from the intelligence committees and what more could be done, and a lot of people have a lot of different views on that. In my experience, having been doing this for a decade, we feel very closely overseen by the intelligence committees. People are up there all the time with briefings. We're providing all kinds of information and reports, and they're weighing in, making line item by line item decisions on budget matters and things like that. And then, of course, the judiciary, it was great to have Judge Robertson up here on the panel. Other judges have also been speaking out about their experience in the Foreign Intelligence Surveillance Court. And I've said this before, and other people have said it. In my experience, anyway, it is by no means a rubber stamp. They are rigorous. They are careful. They have a staff that asks a lot of questions. And we spend a great deal of time keeping the Foreign Intelligence Surveillance Court informed. If there are compliance incidents, those are promptly reported. If the court gets concerned about a compliance incident, they will write a sometimes blistering opinion, some of which we've now released, and people can see them. So in my view, they are a very real, tangible presence that we must respond to and we're required by law to respond to. And we feel a very important part of the whole system. As for me personally, one of the things that I focus on is making sure that I have a seat at the table. I'm there with Director Clapper, with other intelligence community leadership, to make sure that they are provided the civil liberties and privacy perspective. And where do I get that perspective? I mean, some of it I do from reading and everything. Some of it I do, a lot of it I do from trying to talk to advocates, trying to arrange for sessions where the advocates can come in and speak directly to intelligence professionals, which I think is the most helpful to have that engagement. I'll just close by saying, I recognize that even though we have this system of many layers, what I call many layers and many players, and it's very complicated, it is not a perfect system. There's things that we can do to improve it. As you know, the administration supports the USA Freedom Act, and that will include changes to the FISA court. It includes additional transparency requirements, which we support. We have been doing a lot to promote transparency. Director Clapper has directed me to coordinate the efforts of the intelligence community to enhance transparency. We understand we need to be more transparent for public accountability. It is inherently difficult for an intelligence community to ingrain within their culture the need for greater transparency. The whole culture, the whole system is structured around making sure that we keep our sources and methods secret so that we can be more fully effective. As I've said before, a fully transparent intelligence service will be a fully ineffective one, and we might as well not have one. So to the extent we're going to have one, they need to be able to keep secrets. And really a lot of the church committee structure, the structure that we created following the church committee, was an effort to provide controls and oversight in a classified environment where people could speak in trusted spaces to other cleared people, bring forward all the information they can. The church committee, of course, was a lesson in transparency because a lot of that information was made public. And we really need to figure out how to do that better. And so that's what we've been working on.
And I just want to back up something that you were just talking about, which is this idea of sort of more outreach and more conversations with the civil liberties community, which is something that I've actually been very impressed with what your office has done and the amount of times that we have actually had a seat at the table to talk to you. And I think, at some point, hopefully that translates into changes in policy, but that aspect of it has certainly been significant. And I don't want to put words in your mouth, but do I hear you saying that we should expect you to succeed because it's not just you, because
Correct.
there's more of an ecology of oversight that you are a part of? Is that?
Very well put. You can put those words in my mouth and I'll accept. Yes.
Okay, just want to make sure that I was understanding you. So, okay, I'd like to go back to Michael and sort of go back to fundamentals here. The Constitution, which, as I mentioned, as we all know, relies on the three branches to check one another. By entrusting and relying on inspectors general to check their own agencies, are we putting our eggs in the wrong constitutional basket? Are you performing a role that Congress and the courts really should be performing?
I think our role is very different from what Congress and the courts perform. I think structurally that isn't what we were set up to do. We're there to be the internal watchdog. We're there to be within the organization but independent of the organization. We have within the DOJ Inspector General's office 450 people working for us. We have about 30 lawyers or so doing the oversight we've talked about, much of it in the intelligence community and the space. The reports that we've put out, those are the ones being done by the 30 or so lawyers in our Oversight and Review Division. And that's what we're there to do. We're not there to substitute for congressional oversight. We're not there to substitute for judicial oversight. It would be a mistake, I think, to think that that's our role. Having said that, we also report to Congress. If you look at the IG Act, there are a number of provisions that require us to report to Congress. I am regularly briefing members of Congress. I'm regularly testifying before Congress about our work and making sure they're well informed about what we're doing. So we have dual reporting responsibilities. We have responsibilities to report to our agency leadership, and we have dual responsibilities to report to our congressional oversight committees. But we're independent of both. And we have to absolutely both in practice, in perception, in reality, make sure that we've kept that independence.
Does anybody else have any thoughts on this question of how we should think of internal oversight within the sort of constitutional scheme of separation of powers?
One of the metaphors that's used often, and I think Locke Johnson used it, is this idea about oversight as the police model or the police on the beat kind of model versus the fire alarm model. One of the things that Congress needs if it's going to do an oversight job is it needs to know who to ask. Now, one method is internal secret sources that we also heard about this morning. But another method is for there to be offices within the executive branch that Congress asks to report to it, and particularly to report triggered by certain things. So when I was at DHS, I don't think you have this same statute. So but when I was at DHS, one of my requirements under my foundational statute was that if I gave advice to the secretary, I had to report. It had to reach a certain level of formality and so on, but certain kinds of advice had to be reported, and the agency's response to that advice had to be reported. Now, that's actually quite useful to the Congress. In some ways, it's intimidating to the person in the role because it means if you give advice, you have to report it to the Congress. And so it has a complicated kind of reverb. But But nonetheless, it can be quite useful to the Congress that wants a fire alarm, that they can say, wow, is this the kind of issue that somebody gave advice on and that advice was rejected? And so you get sentences that you've read that say even the department's internal office of whatever said that they shouldn't do that. And that actually turns out to be quite useful to Congress. So I think that, you know, Congress is a they, not an it. The executive is a they, not an it. Everybody. It's all about this complex web, this ecosystem of action and reporting and compliance. And I think that these offices can be a really, so it's not an either or. Although the dynamic that you talked about, that Shireen talked about, is real, right? But it's not generally an either or. It's a both and. These kinds of offices help Congress do its job better.
Michael, you
And
had,
I was
yeah.
just going to say, and I think something to understand and appreciate is how different Alex's office and my office is. We're both in our agencies, but for example, I don't have a seat at the table, and I don't want a seat at the table. I have monthly meetings with the Attorney General and the Deputy Attorney General, but it's just the OIG and either the Deputy or the Attorney General. I'm not in management meetings. I'm not part of management at the Justice Department. We've purposefully not gone to regular meetings at the department because I'm not there to give advice, informal. I'm giving it, when we make a recommendation, it's in a report. Assuming it's not classified, it's public. That's how we speak, and that's how we work. And yet we're both within, structurally on an org chart, the executive branch and within the agencies.
And if I could just
Absolutely.
add to that, just as a point about institutional design, I mean, I think there are these different roles of internal institutions. So when we're talking about oversight mechanisms or internal institutions within the executive branch, there is a spectrum from those that have more of an internal advice function and those that have more of an external review function and auditing function. I think what's really interesting is when you put those two together within the same institution, and actually it might be interesting in hearing David Medine's view on how that works, but then, I mean, there's actually some tension between those two roles. Right? So you release a public report that's very scathing of particular programs within the intelligence community, and then you're also involved in meetings with those same agencies to proactively kind of design policy on a set of issues. And so the dynamic of putting both those functions in the same institution, I think, creates some interesting challenges.
So
Yes.
if I could just piggyback on that, I think I absolutely hear what you're saying. It is a challenge, and I won't speak for David, and he can talk about the board as much or as little as he wants on that topic. But from my perspective, it's very helpful to have an institution like the Privacy and Civil Liberties Oversight Board available to provide both advice and oversight. So that duality of function can be very, very helpful. These are people brought primarily from outside, or entirely from outside, who have a capable staff, and we can consult them in a classified setting, in a setting that the intelligence officials trust, for advice to make sure we avoid problems. Because ultimately, we want to avoid those problems from happening, to get to the policy kind of function, which is how do you structure and design activities so that they are, in fact, appropriately addressing all the privacy and civil liberties issues. And you can only do that with people getting involved early and providing advice rather than waiting for the problem to happen. I understand what you're saying about keeping those functions separate versus together. I just wanted to say that in this particular case, I think it's helpful. The other thing I just wanted to point out is that a lot of times the executive branch function, as it responds to oversight from Congress or the need to keep the court appropriately apprised of all the issues that might arise with their orders, is a resource demand on the executive branch. It takes, particularly for the intelligence community, the people who are most knowledgeable and have the greatest expertise on a particular activity that somebody might be reviewing, be it the board or the court or the committees, are the same people who are actually implementing those activities from a national security perspective. So you are pulling them away from that work in order to provide, information and briefings, which, in my experience, I know that you have had a different experience recently at FBI. In my experience, they are willing to do, but we just have to recognize that there is a requirement. It's a draw on their unlimited resources. And one function that offices like mine can serve is to help, manage that, help structure it, so that we can find ways to provide the information that's needed while still allowing the subject matter experts to do their main jobs.
Okay. I have a question I'd like to throw open to any and all of you, which is just quite generally. I mean, we are trying to have an inquiry today on how to strengthen oversight in various different areas. And so the question I have is, where do you see the gaps? And what do you think can be done about them? Where are there shortcomings in internal oversight, some of which may be inherent, and there may be nothing to be done about them. But then where do you see the potential to really strengthen internal oversight? And anyone should feel free to jump on in. Go ahead, Shereen.
Yeah, just a few things I would throw out there. I mean, one is that, we mentioned the differences among IGs. Some differences are just, due to individual leadership or culture of institutions and so forth. But the fundamental kind of statutory formal legal distinction that remains is that some are not presidentially appointed. So for example, the NSA IG is not appointed by the president. And I think that is something, if we're looking for very specific things where we might want to consider a change, could be something to do. So in the past, there was a point at which CIA had only an internal IG, and then after Iran-Contra, there was a push toward making that position a statutory one, which was presidentially appointed. And similarly, when you are not reporting to the NSA head, but to the president, that might create at least more of an opportunity, or for that position to view itself in more of a staunchly independent fashion. A second thought on that is so the Privacy and Civil Liberties Oversight Board, I think, has done some wonderful work. But when we think about capacity and the fact that this is an institution that has one full-time person, 4 part-time board members, a budget that I think is now a little bit above $3 million, which is where it was a few years back. And just thinking about that in comparison to the $50 billion in the intelligence community, we're still talking about a very striking mismatch between the review and what is being reviewed.
So resources.
So resources. Yeah. And I'll just mention one final point where I think that there's something to be done. I think it's incredibly important when there are statutory mandates for IGs to conduct particular reviews or to assign them, as the DOJ IG has, a kind of ongoing role in reviewing questions of individual rights. And because many IGs do not see that still as something that's sort of within their ambit, there are some that say, fraud, waste, and abuse. That's a number of things. But I think to the extent that Congress, to the extent that it legislates at all, but it would be, provides more specific mandates that make explicit a role in reviewing a certain set of issues of which we would have concern. I think that would be an additional area for improvement.
So I'll speak to kind of one more layer towards the internal, away from the IGs. The issues in internal compliance kinds of shops or policy shops and how they balance that role, what they have to do, the challenges to them are a combination of expertise, commitment, and influence. And the expertise one is relatively easy, actually. You wouldn't think that expertise would be easy, but that one's relatively easy. But commitment and influence, the more committed to a value that is a constraining value rather than a primary mission value, like the value of civil
privacy
liberties.
versus surveillance,
For example. The more committed you are to that constraining value rather than the primary mission value, the more antagonistic it is possible for the relationship to get. And so there's 2 ways for an agency to deal with that kind of idea. One, they can hope and help that the commitment erodes. And they can, so the people in the office can kind of get it's the equivalent in the State Department of what they call clientitis, right? So they can lose the very reason why we have them, which is that they're actually supposed to represent a slightly different value set than the agency as a whole. And so they could lose the commitment, or they can lose the influence, and they can be tamed by having no authority and no influence, right? So if you're going to maintain inside an office like that both commitment and influence, then that needs to really be carefully considered. And I think there are a set of policy tools that offices like that can be given. They can be mandated certain kinds of roles, access to materials, access to information, not in the same way that you have it, not in an investigation kind of a way, but in a, you know, sort of what they need kind of a way. They could be mandated to have clearance functions of various types. That if the office objects to something, that it goes up a level before it can be decided, that kind of
So
thing.
not security clearance, but to
Oh,
clear policies,
no,
to
if they
clear
don't have security
documents.
clearances, they're toast.
Right.
Right. Right. They got to have
Okay.
security. Yes.
Okay,
I'm
just
talking about
clarifying.
clearance within an executive secretariat kind of a functionality, right? Sometimes this is called coordination, but clearance. They can be authorized to do some of the kinds of things that Alex was talking about, where this is for the commitment rather than the influence idea, that where they have a set of fairly structured interactions with folks who share the assigned commitment to kind of keep it in there, right? To keep it salient for them, because it's very easy in the IC to just kind of be in the IC. I mean, you walk into a building that nobody else can come into, and you do all of your work in this skiff, you know, and it's very easy to get clientitis. It's very easy so if you think of these offices as boundary spanning offices instead, and you think it's actually part of their role to have significant engagement with civil liberties advocates and to be part of bringing the views of those civil liberty advocates into the agency in ways that can be managed. And other ways too, if offices like that hire from civil liberties organizations to the extent they can, or if they think of that, if they share across government, that's another way of reinforcing commitment. You're trying to create a reference set for people inside offices where most of their colleagues are assigned to a different mission. And it's very important to always keep in mind and to really think fairly strategically about influence and commitment all the time. How can we reinforce influence and commitment? What can we do to do that? And so
Margot has a wonderful article on this that you should all read, and it's called Offices of Good, what's it called?
Oh, so the one about the IC is called Intelligence, Legalism, and the National Security Agency's Civil Liberties
The other
Gap.
one, the Offices of Goodness one.
Offices of
That's
Goodness.
the influence and commitment one.
Yeah, it's true. Influence without authority in federal agencies. That's what it's called. Influence without authority. It's
But it's actually quite optimistic, despite the way it sounds.
It is. It
Yeah.
says it's possible to have influence without authority. But I think that needs to be really considered. Like, no fooling in the statutes, that kind of thing.
What do you think, Alex? I mean, what are the gaps? You are in this role now. What are the gaps that you perceive? What could be done to make you more effective, to make your job more effective at your job? What tools would be helpful?
I have to think about that one. So it's a very complicated ecosystem, to use your term. There's a lot of players, a lot of different moving parts, a lot of people focusing on different aspects of the issue. So that complexity is something that we have to manage, and there's a couple ways of going about it. One is to just cut through it and simplify it. So impose a new structure. This is too complicated. Let's figure out a new way to do it. Another one is to recognize that complexity exists, that it serves important purposes. It's good that our offices are different. It's good that I'm different from the lawyers, but I'm not the intelligence person doing the job. So how do you carry out all of the work that we have to carry out? How do you find how to maintain that balance between national security and protection of privacy and civil liberties in a very complicated environment? It's complicated legally. There's a lot of different rule sets. Depending on the type of activity, and the oversight structure is also complicated. So one answer that some people tend to have is let's create a new entity, let's create something new, and that's fine. Like if we support the idea of an adversarial voice to bring diversity of views to the FISA court, but let's think through what. It would be very helpful to me personally if people thought through what are the downstream implications. They're going to have to get clearances. They're going to have secure space. They're going to have secure staff. Or are they? I don't know. I mean, we're going to have to think through all those issues. That's just an example. And then how are they going to interrelate with all the different players? So if we could have greater recognition of all of the moving parts when people start proposing different things, that would be very helpful to me. When people enact a new rule, if it was a clearer statement of what the rules should be, that would also be very helpful. And if
But then what would the
people,
lawyers do?
and people should recognize the resource constraints. So yes, we can do additional layers of reporting. The transparency effort that I'm currently working on is very important and good, but it's competing in a world of limited budgets with other priorities. And so if you add, for example, more reporting requirements to more committees, someone's going to have to write those reports. We're going to have to tax the people working on the stuff to prepare for those reports. That may well be well and good, but I just want people to recognize that that's the downstream effect. We're going to have to make sure that the resources are appropriately allocated. And if you want more people working on these oversight efforts, which is actually what I would think is, certainly fine. I'm happy getting more staff and other people getting more staff. It's either the total pie goes up, or in a limited pie, those resources get shuffled, and so what are the trades? And so those are the kinds of things that, to me, what would be most helpful is a greater recognition of all of those issues as we go forward.
Did you want to speak to this at all?
Just
What would make
I
your
guess,
job
couple
easier?
things. Obviously, the access issues, not only the legal issue that I mentioned before and having that resolved and being able to move forward and get records without lawyers jumping in with all the legal objections they want to raise, but timely access to records, getting them promptly. That means, if that means us having to get direct access into records, as more and more systems are now electronic, we've got to think of ways to get access in a more timely fashion so that we can do our work more timely. There's nothing, I can tell you, more debilitating to our staff than spending months trying to do the work and plow ahead and ask the hard questions and not be able to get the record so they can ask those kind of questions. Resources are an issue. We have 450 people in our OIG. That sounds like a lot, but the Justice Department has 100,000 plus employees, a $28 billion budget or so, and we look at everything within the department, or almost everything within the department. So there are always resource constraints, always resource issues for us. I think the other thing is we try very hard to follow up on our recommendations, not just put them out there and hope they get implemented. The reason you see the next NSL report, the next 215 report, all the other follow-up we've done, not only in the national security area, but in all the other areas we do those, is so that people don't forget, and the FBI and others in the department know that we continue to watch over them. But having the follow-up that occurs with oversight hearings in Congress, whether there's follow-up through the administration, that would be obviously very helpful for us. And then finally, there is the bill in the Congress, in both the Senate and the House. It would give us testimonial subpoena authority, much like we have documentary subpoena authority. And I think that would be something that would help us with former employees who we can no longer reach if they retire or leave just before we want to question them.
And what, if anything, could be done about the issue of getting reports declassified in a more timely way and getting them out to the public?
And that's a very significant question. One of the challenges we face is we don't have the authority to declassify. It goes through the intelligence community. And usually, and frequently, our reports touch on agencies beyond the FBI. So we're not only dealing with the FBI, we're dealing with other intelligence community agencies over which we are not the Inspector General. It doesn't help us often with the FBI even, but we at least have that relationship with them, and we work with them and we sit with them in the sense of, when I say work with them, trying to get these declassified. And the biggest challenge we have in this area is often getting to the final stage. It's an iterative process. It's almost like there's an effort for it to be a negotiation, and it's not going to be a negotiation from our standpoint. We try and take a very principled approach to what we think should be declassified, and what we end up with is oftentimes the first version coming back to us of proposed declassification being classified at a higher level than some of our earlier reports that were public. And then our shop, having to be the ones that go back, marshal the evidence, marshal the information, and say, by the way, did you know that the CIA director or the DNI or the FBI director or others testified about the following? And here's what's already out there. Or here's what's been reported publicly. And it's that process that takes months, if not over a year.
Such a waste.
it's a very significant challenge, and there needs to be, and we've been talking with the leadership at the department about how we can move this along better, because this cannot continue.
Right, I'm going to interpret the mood lighting as a sign that I should move on to questions from the audience. I do know that David Medina, I believe, is still here, and I did want to give him the opportunity. Is he here?
Yeah, he's
Oh, there he is. Hi. I did want to give you the opportunity, if you'd like, to talk a little bit. I mean, I consider you, and we've got 3 branches of government, you are closer to internal oversight than you are to congressional oversight or to legislative oversight, even though you are, in fact, an independent office. What can you tell us about your experience? I don't, open-ended,
Well,
whatever you have in mind.
Hello? Okay. One thing I thought I might address is the point raised earlier about our relationship between oversight and advice, which is, we have both of those mandates, and I think as Alex has said, hopefully our advice is valuable to the agencies as they develop new programs. And we also, as Margot said, we have something in our statute that requires us to notify Congress if an agency comes to us with a proposal and we say don't do it, they do it anyway. So we're working at the relationship. I mean, one thing is that oversight is proactive. We can oversee whatever we want. Advice is reactive. They have to come to us, seek it. So we have to create an atmosphere where they're going to want to come to us. So we're working out that dynamic. But I think where we're going to probably end up is just because we give advice doesn't mean we can't do oversight on that same area or that same project. But the thing that we would not do oversight on is, why didn't you follow our good advice? But the oversight will be looking at the law and the policy and so forth. Did you end up with a good solution despite our advice, or hopefully consistent with our advice? So it's a challenge to have both functions. But I think as we develop more expertise in this area and work in relationship with both advocates and the intelligence community, I think we could provide value on both sides.
Any questions? People down in the front and in the back?
Steve Winters. I wondered if the panel felt there were any lessons that could be drawn from this couple of decades of experience with the Freedom of Information Act. There is a law school here in DC that has a very good program to sort of tracing how that works in practice or doesn't work in practice. And there you have this sort of internal situation too, because each department has to have appoint a FOIA compliance officer. And apparently the experience is that some branches of government just don't like to respond to these things particularly well, and you get a very bad experience, and others are much more forthcoming for whatever reason. So is there any lessons to be drawn from there? Because that program probably hasn't worked out as originally conceived.
I think that the FOIA system is a really important part of, I keep calling this an ecology or an ecosystem, but I think it's a really important part of it in a few different ways. One, it enables the public to be a part of the system where otherwise you'd have to sue somebody. I mean, you already have to sue them because you have to sue them to get them to answer the FOIA request, but it's a very different kind of lawsuit. So a function where in the closed world of the IC, which used to be more closed, is less closed now. So just a couple of weeks ago, the CIA AG guidelines under 12333 were released. That's pretty cool. And that means that people can read them and then can then say, hey, we think those are great in these 3 respects, but kind of pathetic in these other ones, and wouldn't it be a good idea, since you're redrafting them anyway, because everybody's on the CIA everybody's on everybody to redraft their AG guidelines, wouldn't it be good to change them in this way? And so it enables a public conversation from FOIA that couldn't happen. The other thing is that the FOIA stuff interacts with these internal offices in a way that's really interesting. So one of the most interesting sets of FOIA materials are the IOB reports.
Intelligence Oversight Board.
Yes, which are pretty much all available.
Can you just tell people what those are?
Oh, yeah, so the inside I get this wrong sometimes, but inside the IOB is inside the executive office of the president, and there's a set of reports that are both routine and reactive, both, that have to go to the IOB. And so various kinds of non-compliance, not with FISA so much as with 12333, some of those non-compliance incidents go to the IOB, and you can you can, those reports have been FOIA'd, and there's a lot of information in them. So it's an internal oversight office that generates the material, which then gets released into the public by way of FOIA. And that's a really important dynamic as part of this.
But I think your point is that it's not working
I get
very
that wrong?
well, right? Or, sorry, go ahead, Alex.
Oh, I was just going to piggyback. So in some ways, you should ask that question to the people submitting the FOIA request. But FOIA is an essential part of how we're going to how we're dealing with enhancing transparency. It's particularly challenging for the intelligence community because of the classified information. And one of the so we've been working very closely with FOIA officers in trying to figure out how to manage their set of issues, and also working with external open government folks. We're going to want to do that some more. But there's a couple of things about FOIA that I think are important to understand. One is that it's a forcing mechanism. So and that's good and bad in terms of from the inside how you manage your own priorities. So your priorities are being set by the litigation deadlines, which are coming in because of whatever FOIA request is the first in the queue and has been the first to get to the court and has that litigation deadline. So you're with limited resources, you're on something of a treadmill to answer the next FOIA litigation. So when I come in and say, wouldn't it be great if we had greater transparency in this? And they said, that's fine, Alex, as long as you take care of these FOIA requests in our queue. Those FOIA requests have increased in the last couple of years, as you can well imagine. So that queue has grown longer, and the people are running harder and harder to release those documents. The other thing about FOIA is that it is, you look for records, you look for government documentation that already exists. I can't create an explanation that I think would be transparent and understandable. So as a result, you get a lot of technical documents, redacted text inside of them. They can be very difficult to understand in context, and oftentimes the FOIA requester is a particular researcher or subject matter expert. They may understand it because it fits within all the prior releases, but if it's posted for the general public, it's hard to make sense of it. What does this mean? It's a document sort of in isolation. So it's an essential part of what we need to do for transparency, but not enough. I mean, we have to figure out ways to better explain ourselves with context and in a manner that is more understandable to the public.
I don't know whether to call him Birchville. You guys take turns. Down here, down front. Do you guys have a microphone? If you want, you can go ahead and I can translate.
No, there's somebody who
there's
has
somebody with
a mic up there.
In the top.
Okay. Okay, down here, please.
Liza, there's somebody with the mic up in the top.
Oh, I'm so sorry. I'm going to go to these guys, and then I'll go back up to you. Sorry, I didn't realize you had a mic.
Could I ask the panel how they would respond to the previous panel in which a case of agency abuse was very graphically described? How would you help her?
And we're talking about the first panel of the morning when Diane Rourke was speaking about. Were you folks? So
He wasn't.
yeah, I know
He
you
was
weren't
the
there.
most definite.
Yeah. Does anybody who's here want to?
So I
respond
think,
to that?
so to me, when somebody has a concern about the legality or the appropriateness of a program, it's essential that we have a mechanism in place to give that person, I'm not speaking about that situation specifically because I'm not familiar with it other than.
Well, I'm speaking about it.
No, but I can't, I'm not trying to address the specific facts. I'm just going to give a more general answer, which is it's really important for us to put in place trusted mechanisms that employees can rely on to bring their concerns to the appropriate folks. So the two things that we are focusing on internally are making sure that people understand what those what those mechanisms are, and making sure we have safeguards against to protect that employee from possible retributive acts. And I'm not saying that that's working perfectly. It's very there are challenges in making sure that that works correctly. I also think it's important to understand that in some cases, if the person who is the best person to receive the information, the concern of the employee, already knows of the program and has approved of the program, it's unlikely that that person is going to change his or her mind. So the other angle that we are going to be pursuing is to what extent can transparency help in that regard? What extent can an employee request that this information be made public in some way through authorized channels? And so there is a mechanism in the executive order for declassification review This is the classification order on the executive order on classification. So we're looking at that, exploring that. Is there a way that we can streamline that process so that an employee who has a concern about something and says, I want this to be transparent, I understand all the people involved have already reviewed it and approved it, but I think the American people should hear about it. To what extent can we put in place a declassification review process for that?
All right, and I'd like to go back up there. I apologize for.
Hi, I'm a student here at NYU. I'm studying international relations in the master's program. I'd be curious to know if any of you in your research or your own work, or maybe by looking at other countries and trying to look at this comparatively, have you ever seen another country that strikes a better balance, in your opinion, between civil liberties and security? Maybe they have a wonderful security situation in terms of homeland security, but have more expansive civil liberties in terms of strengthening oversight. And maybe you could talk a little bit about that country and how, or maybe it's a group of countries, and how that can possibly be a model of something that America can aspire to.
I think it would be lovely if there were a country out there from which we could learn how to strike that balance better. And there may well be countries that in their operations strike it better. I don't really know how I would know that, honestly. But I don't know how any of us would know that. But I don't think there are countries that are experimenting more than we are with the oversight mechanisms. Actually, when you talk to people from other countries, they're somewhat, I mean, we've all been talking about the failings of our system, but they are somewhat astounded at the levels and variations of oversight. And so no, the answer is no.
We know less, of course we know less about the other side, right? I mean, I suspect there are no countries that are experimenting more with methods of surveillance than our country is. I'm not talking about breadth of surveillance necessarily, and I'm not talking about, whether human rights are protected or anything like that. But in terms of capability to conduct surveillance and to, try to build back doors and that kind of thing, I think, my understanding is that the intelligence community in the United States is better resourced than the intelligence agencies of all the rest of the world combined. So I think it's a little bit apples and oranges sometimes when you try to compare to other countries. But I realize that question was not necessarily posed to me. Let's see. There's lots of folks with their hands up. Back there with the orange, peach shirt.
Sure.
Orange.
Is this on? Okay. Yeah, I'm Laura Ballard. I'm at the State Department, so I work with some of these guys. And I agree with your answer to the last question. Comparative surveillance laws is something I'm actually looking into and studying, and I've found none better. I would say Germany's fairly comparable. But Germany's laws were somewhat inspired by ours, starting with the National Security Act of 1947. But the question I wanted to ask, because we can always make ours better, with regard to internal oversight is, we've talked a lot about the challenges of oversight with respect to the need to handle classified information responsibly. But nobody has really drilled down on the substantial differences in handling that is required for top secret versus secret. This is something I run into. I'm just a person who is normally part of these policy deliberations. If there's going to be a broad-based policy delivery, it have to be somewhat broad. I have a top secret clearance. I've had one for many years, and I have two computers at my desk. One, I can process information from unclassified up to SBU, so I can email Alex and we can exchange ideas and stuff. I can switch over to the other computer and go up to secret. But if I want to process top secret information, I can't do that electronically because you have to be on the JWIC system to do that. And so if I want to handle top secret information, I also have to keep it in a special safe. I can only discuss it in a special room. So I'm often going over to INR, which is our intelligence bureau. Maybe you have a weekly reading session and they'll bring out a few hard copy things of interest to you, and most of them are really boring. But if you did happen to take notes, you have to leave the notes in the room. So I'm wondering, to what degree does that create sort of a separate ecosystem for policy deliberations? And to what degree does that present a particular challenge for oversight, going back to Alex's concern about the sort of downstream effects? I mean, if you're going to set up a bunch of people to play an adversarial role in this process, handling top secret information, it's actually more logistically challenging than you might even think.
So one of the lessons from 9/11 was that we needed to share information better across the intelligence community itself and then with other government agencies. And so we have been working very hard on that. And one of the initiatives under that is to rights to release. You try to write things to a lower level of classification so that more people can see it. Now, that doesn't mean that happens on a regular basis, and also what could happen is you could have one paragraph in a larger document that is top secret, as you pointed out. That means that entire document has to stay in the appropriately certified and accredited systems for that document. So hopefully one of the things that we'll work on in our transparency initiative that is certainly would help address that is to really take another look at these existing policies that we have for information sharing, and then find new ways to make sure that people are actually implementing those policies so that the situation that you described doesn't come up as often. We have to recognize that people talked about secrecy and overclassification. We have to keep secrets, but at the same time, we have to do it appropriately. And it's human nature to try to avoid risk. And the risk that I think someone else mentioned is that a risk of not properly classifying a document could mean that you have given away some secret, and that's a big problem, and all the kinds of issues you guys have been talking about in other forums it would come about. So there's a natural human tendency to make sure that you are erring on the side of marking the documents that you're working on classified. And then there's also a legal reason, or more of a if I'm trying to protect this as the core secret, and I give everybody information all around in this particular area, a large circle, except for that hole, then it's more likely that an adversary will infer that what your secret is. And so therefore, there has been a strategy and an approach, and it's evidenced by GLOMAR, right? Can't confirm or deny over a range of activities to prevent that sort of gaming by an adversary so that they can infer what the secret is based on the information you've released. So that's something that we're also going to have to address. But the bottom line is that it's an important issue, and we have to figure out how to find ways to appropriately classify the information.
I just want to add one thing, which is that this is actually the benefit of the internal oversight technique. The benefit is that you get everybody properly cleared. You give them all access to a SCIF. You actually put their desk in the SCIF so that they have a computer there and they don't have to put their stuff in a safe. And then they can do their job in the right environment and they can actually do it. One of the, I think, really major obstacles to congressional oversight is the sort of only in a SCIF, only in person, you can't bring any staff, you can't take any notes, you can't, all of those can'ts are really inconsistent with the way that members of Congress actually function. But they're not inconsistent with the way that people in executive agencies function, right? People in executive agencies work in buildings with no windows without strenuous complaint. And so actually, you can do a top secret SCI kind of environment and still have internal offices. And I actually think it's one of the reasons that there's been this push on creating such offices rather than being the disadvantage.
And that's certainly the case with us.
Yeah.
And there's no need to know issues. There's no issues with internal overseers being told they don't have a need to know and can't be read into. I mean,
I wouldn't say no need to know. I would just say it's manageable.
The irony of the access issues that we've had beginning in 2010 is we've had access to among the most sensitive documents in the FBI. We did the post 9/11 review. We did the President's Surveillance Program review, which at the time was among the most classified programs in the government. We had a SCIF. We have a SCIF near my office. We have a SCIF where the lawyers are that have done these reviews. We have access to the records. That's not the challenge. That isn't necessarily, it's an inconvenience. It can delay things. It can cause other issues, but it's not really a core problem that we have.
I think we have time for one more question. Bert, I'm sorry, you've had a couple of chances, so I want to ask somebody who hasn't had a chance to speak yet. Okay, sir.
Thanks so much for this panel. I have a lot of pressure now because I have the last question.
Make it good.
I really enjoyed just sort of hearing a bit about the different, frankly, what we have is sort of different models represented on the panel, and with David Shop at P-Club in terms of executive internal oversight, and sort of Shrina referenced the phrase institutional design. So I guess my question would be, or I'd sort of ask you to imagine you have a magic wand, and based on your experience, if you could share with us what you think are the core elements in terms of institutional design of a strong oversight mechanism for the executive. And also, based on your experience, what are the sort of oversight mechanisms in your shops that have been set up that are frankly challenges to be an effective internal oversight agency?
Any order?
For magic wand answers, I defer to.
Oh. Yeah, so right, I think by setting it up as a magic wand, then it's too high a bar, right? Because none of this there is no magic wand. But that said, to my mind, some of the reviews that we know have been incredibly important are those that have pushed back against government secrecy. And so this is not I'm actually not answering this at the level of, exactly how you do that, but, certain features. So for instance, independence, the idea that you do not need to go through the White House before you testify to Congress on a particular issue, or submit your reports for clearance to, those kinds of elements, anything that can, whistleblower protections. I think the whole basket of mechanisms that can improve transparency are really crucial, because for me that goes back to the idea that at the end of the day, we need Congress, courts, the public to be more informed in order for them to have a role in setting what the rules ought to be in the first place. The one other just piece of that I want to say is that I really feel that there is much more that public advocacy organizations, civil rights, transparency-minded organizations on the outside can do. We've talked about the need for police patrol continuous oversight, not just the fire alarm oversight, and I think that applies as well to the civil rights advocacy community, that to the extent that external organizations are watching continuously what the internal institutions are doing, rather than just reacting when the CIA IG steps down because of problems with or so forth. I think that level of external accountability on the overseers is incredibly important.
Alex, we're watching you.
I want to know what Margaret has to say.
I agree with that. I think that the closest thing there is to a magic wand is public discussion. And so as much public awareness on the level of sort of policy as we can create is good. And then the public, which is really channeled through organizations that develop expertise and context and attention and so on, they can really pay attention to what hopefully are their allies within government and what those people are doing, and hold them to account and hold their feet to the fire. The other thing that I would say is that we need to not allow the executive to substitute legality for virtue. And I think that's really, really important. We need to, when somebody stands up and says, I don't know why you're complaining, it was legal, you need to say, you didn't answer my question. That, if it was legal, and maybe it wasn't legal, right? And this is the argument that I have with Liza fairly often, but maybe it wasn't legal. But if it was legal, that doesn't mean it was good. And we need, as a public, to hold the executive branch to account for doing the right thing, not just the legal thing. And those two things are for me, what I would say.
An applause line.
Just briefly, in terms of internal watchdog, I think you've got to have independence. For example, my position, I can't be removed by the Attorney General. I can only be removed by the President. You have to have transparency. You have to be able to be transparent, which in some instances is harder than others for us, but that is one of the principles we stand for and we strive for and we continually try to accomplish. We have an independent budget line. We can't have our resources taken away from us by the agency because they don't like what we're doing. So we have that ability, even if we might need more resources. Our budget line is separate from the department's budget line. And in addition to access to information, as I mentioned, we need to, and you mentioned whistleblowers, we haven't really talked much about that, but we need to have employees be comfortable within the Justice Department, I'll speak for my agency, coming to us with information, whether they call themselves whistleblowers or not. We need people to come to us with information if they have concerns about how programs are operating, whether they're in compliance with the rules, regulations, with the practices, whether they're being abused. That's something that's very important, something we've worked very hard to do. Before I got there, I've certainly tried to redouble our efforts in that regard. It's very critical that employees be willing and able to come to us. It is one of the advantages of being internal Because if you look at study after study on individuals, employees, whether they are in non-government agencies or government agencies, what you hear over and over again is they want to get it right within their organization. They want to go to their supervisor and get it right. And if they can't have that happen, the next step, if they keep going up the chain, but they can always go to another entity that's within their organization, that's independent, but still isn't going outside. And they need to know that they can come to us.
And you've argued for stronger protections.
And we've argued for stronger
whistleblowers. Yes.
protections as an
And
OIG
makes sense.
for whistleblowers.
Yes, okay. Alex, are you good, or you want to say
I'll
anything?
just say, in my view, if I had a magic wand, now that I've had time to think about it, we would be having more transparency, with the caveat that it'd be appropriate transparency while protecting secrets, so that the public debate that we're having here and that we've been having over the last couple of years continues and is better informed and focused and nuanced on the things that we are actually doing or considering doing, rather than some speculation about what we might be doing or concern. It's certainly appropriate to raise those concerns. And I agree that the civil liberties advocacy engagement is important. We should make that very much an ongoing process so that we can have a better dialogue about what it is that we're currently doing and what the concerns are about those actions as opposed to speculation.
So we've gone a little over time. We are not going to take a break before the next panel. I want to make sure you all know that. So sorry to push you through, but I just want to thank the panelists for being here.
There's not another panel, right? We're just closing remarks.